The last case is People versus McBurrows.
May it please the court, I'm Allison Arnold from the Monroe County Prosecutor's Office for the appellant, and with me is Jonathan Jones from our office. I would request to reserve 2 minutes for rebuttal. Now, the issue in this case is whether there is venue in Monroe County for the charged offense. We're asking this court to reverse the Court of Appeals decision based upon both Michigan Compiled Law 762.8 and 762.5. MCL 762.8 provides venue as acts done in the perpetration of the offense occurred in Monroe County. 762.5 provides venue as injurious harm was inflicted or poison was administered in Wayne County that caused death in Monroe County. Now, the first statute applies as acts constituting the felony occurred in Monroe County. Those acts are the consumption of the fentanyl and the death of Nicholas Abraham. The question for this court is the meaning of the words done in the perpetration of that felony and were committed. Now, as the consumption of fentanyl is an element of the offense that's required for the perpetration of it, which causes it to be culminated, it is an act committed and done in the perpetration of it. The language done in the perpetration of and committed are intentionally in a passive voice with no noun. The language in the statute is not limited to acts of the defendant. The grammatical construction of the statute using the passive voice and the language of the statute shouldn't be ignored. In the statute, perpetration is just a synonym for commit, and here both acts are part of the perpetration of the crime. Or more simply stated, it's impossible for the crime to be committed or culminated without the acts of consumption and death. The crime here is more than the acts of the deliverer, as it is not complete upon the delivery. The purpose of the statute is to confer venue where essential parts of the criminal transaction take place, as there's a nexus to the crime there. And that's whether the acts are performed by defendants, innocent dupes, or victims. Now, furthermore, acts in the commission or perpetration of crimes are not limited to those committed by defendants. The innocent dupe doctrine, as enumerated in United States v. Bryan, supports this and gives numerous examples where innocent dupes are utilized to perpetrate a crime. By Appellee's interpretation of the statute, if an act which is an element or essential part of a crime is performed in a county by an innocent dupe, there wouldn't be venue in that county. Now, the Court of Appeals ruled that the statute simply provides a penalty enhancement whenever the defendant's act of delivery causes the death of another.
Counsel, can I want to, I'm afraid that the construction you urge might have some unintended consequences that you don't like. So so elements of a crime are mens rea, actus reus, and then there are sometimes circumstance elements, right? So you want us to agree with you that the consumption of the drugs and the death are acts done in violation of perpetration of the felony. If that's right, if those are not circumstance elements of the crime and are in fact part of the actus reus, aren't you then going to have to prove that the defendant had a specific mens rea associated with those acts? I mean, right now, this crime can be proved just by proving that someone died. If your construction, if you win, prosecutors now all over the state are going to have to prove that a defendant had a specific intent as to the victim consuming the drugs and dying. Isn't that troublesome for what the legislature intended to punish here?
Your Honor, with respect, I disagree with the conflating acts with actus reus. I think acts is more meant to be elements that are part of the crime.
But there are circumstance elements and there are conduct elements in every crime, right? That's just sort of crim law theory 101. So it's one or the other. If it's a circumstance element, then it's not an act done in violation or perpetration of the felony. It's different.
Well, I think the purpose of the venue statute is to look at where essential parts of the felony take place, and if a part of the felony takes place that gives a substantial connection to that county, then it would give venue there. Because if you look at the common law of venue prior to the statute, it just talked about where the commission of the offense occurred. But here it's saying if the offense is different parts, where one of the parts of the offense occurs, venue should lodge there. I don't think it relates to intent. In Plunkett, the Court of Appeals talked about intent, and I think the Court of Appeals, this isn't a case about intent. It's about if an essential part of a crime takes place within a county.
Well, I understand. I'm just trying to tell you that I think your construction might cause some unintended consequences if it were to prevail.
Well,
because if I'm the defendant in the next case, I'm going to say they now have to prove that the defendant intended those elements, which right now is not the case.
And I don't think it would have to translate into that result. I think if an essential part of a crime takes place within a county that's foreseeable by the defendant's conduct, I think it's more a question of foreseeability than intent. And here, because this consumption is so closely connected to the intent of the delivery, there doesn't have to be an intent for the death. I mean, the consumption's foreseeable with the intent of the delivery, so I don't think you need an extra mens rea.
Sorry, Steve.
I mean, in the crime of delivery causing death, the court said in Plunkett that the crime of delivery causing death, when talking about Plunkett's culpability, that the crime of delivery causing death, that the intent is complete upon the delivery. I mean, that was part of the rationale in Plunkett, so I don't think my interpretation would change that. But here, the crime is the culmination of the acts of delivery and consumption and the resulting death. Because all acts are necessary for the offense, and the court doesn't have to reach, the court could rule death is not an act, but consumption certainly is. And they do result in the culmination of the offense. So we would argue there should be venue here. Now, the second statute, Michigan Compiled Law 762.5, provides if a mortal wound shall be given, or other violence or injury shall be inflicted, or any poison shall be administered in one county by means whereof death shall ensue in another, the offense may be prosecuted in either. We are arguing here under that statute that the delivery of fentanyl to Nicholas Abraham in Wayne County was an injury inflicted upon him that caused his death. Now, when you look at the Southwick case, Southwick makes it clear that a mortal wound doesn't have to be what we think of as a traditionally inflicted injury like a shooting or stabbing. In that case, the introduction of bacteria through instruments when an illegal abortion was performed was considered a mortal wound when death resulted multiple days later in another county. Here, the statute goes even broader than the mortal wound language because they use mortal wound or other violence or injury. So injury is a category that is above and beyond mortal wound or violence. It's used in the broad sense, the broad term.
Counsel, I have a question. Just the jurisprudential component of this in terms of judicial efficiency, isn't this going to require, I mean, the vast majority of your witnesses and people are in Wayne County. So now you're going to have under your argument, you're going to have a trial in Monroe County, but the vast majority of people are going to have to come from Wayne County to Monroe County. Are you concerned at all that, if this were to go forward, that in a situation like this, the participants, the witnesses, the police, the detectives, all the people that are kind of involved are now going to have to travel to other counties that are kind of outside the purview of where the act took place?
Well, I think that's a very legitimate concern, and I think that ties right into the purpose of the venue statute, which is for convenience of the parties. But I would think that in most situations, the converse would be true. We know that Wayne County is a source city for opiates and that they go from Wayne County all throughout the state. We just happen to share a forensic examiner. They do our autopsies by contract. Wayne does Monroe County's. But Wayne County, heroin from Wayne County would end up from Monroe County all the way up to Houghton County. And if you consider a case where someone dies in Houghton County, typically the investigation is going to be commenced where the death occurs. And consumption and death would most often be in the same county. So two of the elements would most often occur in another county, and the investigation would initiate there. The forensic testimony would be originated out of that county. So I would think in most circumstances, because the county where the death occurs is where the death is going to be originated, the bulk of the witnesses will be there. And oftentimes the crimes are solved through electronic evidence such as cell phones, through intermediaries who do the delivery. That sort of evidence typically is going to be in the county where the death occurs, not where the delivery takes place if it's in two different places.
Can I just clarify your analysis a wee bit here? I think I'm inclined to agree with a good part of your analysis, but let me just understand very precisely one aspect of it. Perpetration presupposes that somebody is perpetrating something, that there's a perpetrator somewhere. The act of perpetration is, I think, roughly defined as carrying out or performing something, along with kind of a sub-theme or connotation that's what's being carried out or performed has an element of wrongfulness or criminality to it. Who precisely is the perpetrator of the second act that I think you correctly identify in this case having occurred in Monroe? Is Abraham, in your view, the perpetrator of that act?
Well, when we look at perpetration, I
want to focus on perpetrator. As I say, I think perpetration requires somebody who's engaged in the act of perpetration, right?
It does, but the statute uses the phrasing done in the perpetration of. Still,
there's a perpetrator there somewhere in the mix, isn't there?
Well, I think it's part of what lends to the perpetration. I think here, if you look at perpetration as a synonym for committing or doing, I would argue that both Abraham and McBurrows are both doers. I mean, Abraham does engage in a wrong act, so I guess in that sense he is a perpetrator. But I think it's more a synonym for a doer, someone who does something.
Well, who is the doer of the second act?
The doer of the second act would be Abraham, but it culminates in the perpetration of the act by Abraham, which is what the venue statute requires.
Okay, I appreciate it. Thank you.
Additionally, we would argue that fentanyl should be considered a poison in this context, too, that was administered by McBurrows, because poisons are inherently deleterious substances. Strong opiates, when given not in a medical context, especially in a case like this where someone who is a heroin addict thinks they're buying heroin and ends up with fentanyl, we would argue that the substance should be considered a poison in that context. It was administered by McBurrows. Administering means mete out or dispense, and it was used by Abraham. Thank you.
Thank you, counsel.
May it please the court, my name is Noel Aaron-Jerry. I represent the defendant appellant Romon McBurrows. I'll waive any uninterrupted period. Your Honors, the charge here is a square peg, which is called delivery causing death. The state is attempting to fit that into two round holes, which are 762.8 and 762.5. With regards to 762.8, the key phrase is two or more acts done in perpetration of the offense. The offense here is the alleged transfer, the alleged delivery, a single act. There aren't two or more acts to consider. The crime was complete when the transfer happened. The transfer happened in Wayne County. Therefore, Wayne County is the appropriate venue, not Monroe County. There's a discussion of, the state makes, they attempt to conflate acts and then also elements. And as I think Justice McCormick pointed out, those are two different things. There are certain elements of crimes which are not acts. One example would be take driving while license suspended. One of the elements of that offense is that he was driving on a public highway. Public highway is not an act of anybody. So acts and elements are different. And when it comes to perpetration, I think Justice Markman correctly pointed out that there must be a perpetrator. There's no statutory precedent, there's no case law precedent that says that a perpetrator is someone other than the defendant, other than, or possibly a co-conspirator. But if they're alleging that, you know, Mr. Abraham was the victim, he can't simultaneously be an innocent dupe and a perpetrator. A perpetrator is someone who does something intending to reach some sort of object. And in this case, if the object is the death of Abraham, I mean, you can't say that he was intending to cause his own death. That's both extremely unlikely, and there's no evidence in the record as to that.
Is there an arguable distinction in this case in light of the fact that Abraham did do something that was independently a wrongful act, or maybe even a criminal act in some sense? Does that transform his situation from that of the normal victim?
I don't.
In terms of the assessments, the assessment of acts that have been perpetrated, is there some greater potential to characterize his act, his conduct in this case, as being the perpetration of essentially a wrongful act that, along with the perpetration of another wrongful act that preceded it, conduced to produce venue in Monroe County?
No, Your Honor, because it's the first wrongful act that is the object of the statute. That is the first wrongful act that the statute intends to punish. The statute intends to punish the delivery, and certain things may have resulted from that delivery, namely his consumption and his death. But it's the defendant that committed Mr. McBurrows, that allegedly committed the wrongful act that is being punished, and therefore, because that happened solely in Wayne County is the
But if the only act charged was 750.317A, there wouldn't be enough here based on what you describe as the single act of distributing the drugs, right?
I'm sorry?
More would be required in order to establish that there was the commission of a crime here other than the distribution of the substance.
Yes, that's correct, Your Honor. But as Justice McCormick made the distinction between circumstance elements and actus reus elements, I think the consumption and the death are not acts in perpetration, they are circumstance elements.
MCL 762.8 does not state that all the acts must be committed by the defendant, correct?
That's correct, sir.
And is there any reason why the action of the victim can't constitute an act as long as it's done in perpetration of the subject felony?
The subject felony, there's no statutory authority to suggest that one way or the other. It doesn't say it has to be the defendant. It doesn't say it can be the victim.
Okay, so.
So I don't think it can be the victim because they use the word perpetration.
Yeah, what does perpetrate mean? It's not defined in the statute. What does the dictionary tell us?
The dictionary tells us perpetrate is to
carry out.
Yes, Your Honor.
To produce, perform, or execute something.
That's correct. But they also use the word commit, and I think the fact that they use perpetration in one place and commit in the other suggests that those two words have distinct meanings. They're not the same thing, as counsel for the state argues. That a perpetrator is different from someone who simply commits something or does something.
So the consumption was not an act in perpetration of a felony, even though he didn't intend his own death?
The consumption was not an act in perpetration of the felony because the felony was the delivery, yes, sir, and also because he did not intend his own death, but mainly because the delivery is the felony. Turning to MCL 762.5, first of all, the state argues that fentanyl is a poison. That's not the traditional definition of poison. In the context of that statute, poison means something like arsenic, cyanide. You put something in someone's drink in order to kill them. Fentanyl does have certain medical uses, and I'm not suggesting that this was prescribed as part of a medical procedure or anything like that, but fentanyl is not a poison in the same sense that arsenic is a poison or that anything is a poison. A poison is something that is given in a deliberate attempt to kill or murder. Simply to suggest that it has the possibility to cause harm. I mean, if someone has a citrus allergy, orange juice has the possibility to cause harm. You can't say orange juice is a poison. Not without making the statute, essentially meaningless, making it impermissibly broad. And even with regards to, even if it could be considered a poison, it was Abraham that administered the poison to himself. He's the one who went to Monroe County, injected it into himself, and therefore died. Mr. McBurrows, the record shows, was not even aware of Mr. Abraham's existence, let alone that he was going to, that he was even going to take the stuff.
So I just want to take you back to that last question. You told me it's not an act because the felony was delivery, but it was delivery of a controlled substance causing death.
Yes, Your Honor.
So his consumption that caused death, why isn't that an act if we conclude that the statute does not require the defendant to be the one committing all the acts?
It's not that it was an act, sir. It was not an act in perpetration of the felony.
The act of consumption was not in perpetration of what ultimately resulted in his death? Caused the effect. When I look at the dictionary definition again of perpetrate, something to cause or to bring about.
That's
it was
correct.
the consumption that brought about the death.
It was the consumption that brought about the death. Nevertheless, sir, the fact that they use perpetrate at one place and commit in the other, I think is significant. A act in perpetration of the felony refers to the subject felony, the delivery. What happens afterwards, I think, was properly characterized as a sentencing enhancement.
Again, it's the act of perpetrating the felony. You want to limit it to the delivery. It's the delivery resulting in death.
Resulting in death, yes. But a felony resulted in something else. And I think that the single act is the delivery. Yes, I would limit it to that, sir.
So the act of consuming isn't an act at all?
It is an act. It is not an act in perpetration of the felony, sir.
Did it not cause the death?
It did cause the death.
So if we go to the dictionary definition of perpetrate and conclude that that means something to bring about or cause, would we not have a good statutory argument then?
I don't believe so, sir. I think that is an overly broad reading of the word perpetrate in the context of this statute.
Okay.
With regards to 762.5, this is not a poison. Mr. McBurrows did not administer the poison, even if it could be considered a poison. Sister counsel made reference to the Southwick case from the 1930s. So in the Southwick case, Dr. Southwick actually performed some sort of action. In other words, attempted to induce an abortion on the victim. As a result of his direct actions, the victim died in Oakland County. And so 762.5 or its equivalent was properly applied at that time. In this case, that's not what we have. We have Mr. McBurrows allegedly giving this to an intermediary. The intermediary gives it to Mr. Abraham. Mr. Abraham travels to a different county, and then, the consumption and the death. Southwick is not applicable here because Mr. McBurrows is too far removed from any injury that occurred. With regards to the foreseeability argument, foreseeability, the consumption is always foreseeable with the delivery. In other words, if drugs are sold, it is assumed that somebody is going to consume it at some point. Death is not necessarily foreseeable. Thousands of people, unfortunately, ingest drugs every day. The vast majority of them do not result in death, so I don't think foreseeability is a proper basis to interpret the statute. And finally, the legislature has numerous times, both in the general sense and the specific sense, legislated the venue question. In 762, specifically 10A, 10B, 10C, the legislature lays out venue requirements for telecommunication crimes, identity theft, and the like. And there are two other ones, MCL 750.219D3, residential mortgage fraud. They lay out specifically, these are the proper venues for residential mortgage fraud. And the same thing for forgery of a public record in MCL 750.248. It says, that venue is proper in the county where the forgery was made, in the county where the forgery was used, and so on and so forth. So if the legislature had intended that venue be placed in a specific, can be tried in either county, then the legislature is free to do that, and my understanding is there is actually a bill currently that would do just that. But the current versions of M62, 762.8, and 762.5 say that the act, the delivery that caused the death occurred in Wayne County. Therefore, Wayne County is the proper venue and the only proper venue. If there are no other questions, I'll take my seat.
Thank you very much, counsel.
Thank you.
Defense counsel referred to acts done in the perpetration of the offense. Well, here it's acts done in the perpetration of the felony, which culminate in the felony, which I think aligns us with the elements of the offense, which are culminated when there's delivery, consumption, and death. Fentanyl is a poison in this context. There is a poison botulism toxin, which people use to inject in their skin to get rid of wrinkles. The fact that there's a medical use for a controlled substance or for a poison, I mean, they're not mutually a controlled substance and a poison, or something used for medical purposes and a poison, are not mutually exclusive. Here, when the victim thought he was getting heroin and got fentanyl, which is a substance which is 100 times maybe more potent than heroin, it's certainly a poison in this context.
So whether it's a poison depends upon what the purchaser thought they were buying?
Well, I think when someone gives someone an inherently dangerous substance and they don't know they're getting it, then they're being poisoned. That would be our argument. And as far as
So the same facts, and someone actually knows they're buying fentanyl, it's not poison?
Well, I would argue that fentanyl is a poison in any context other than under strict medical supervision, because it's an inherently dangerous substance in terms of its effects other than that situation, just like botulism toxin would be.
Thank you. The case will be submitted.
Thank you.